In this section, I'd like to take you through the minefield of directors' duties. When we talk about directors' duties, what do we mean? Well, there are company management duties, and by that I mean things like filing your annual return at Companies House, filing the necessary forms with Companies House, keeping your statutory books up to date. Not something I'm going to focus on today. What I'd like to focus on are the duties owed to the company by the director under the Companies Act. And what are these? Well, there's a whole list here. I'm not going to read them out. I'll let you focus on them for yourself. What I would mention is that these duties didn't just appear out of thin air. The legislators didn't one day sit down and come up with a whole bunch of duties they thought would be useful. These are duties that have developed over the years, applying common law rules and equitable principles. So, of all of these duties, the one I'd like to focus on for now is the duty to promote the success of the company. This duty used to be known as a duty to act in the best interests of the company. Now, this was a very general duty. However, the Act gives us some criteria which a director must apply when considering this particular duty, and here they are. So, to whom are these duties owed? Well, primarily the company, which prompts the question from a sole shareholder and sole director and owner-manager of a business, well, why does this matter? If I am the company and I owe these duties to myself, what does it matter? Well, to a degree, I can understand that. It's a question of self-regulation. It still matters that you follow the director's duties as set out in the Act, for various reasons I'll come to later, but I can understand the question. Of course, if there's more than one shareholder and you have minority shareholders, you may find yourself on the end of a derivative action. A derivative action is an action brought by a single shareholder on behalf of the company against the directors. Now, they're very rare in history. We don't see very many of them, but the Companies Act does provide for derivative actions to take place. And while we haven't been inundated with them, we can't rule out that we'll see more of them in the future. Of course, insolvency is where everything changes. Insolvency, I like to call it a game changer. When a company is insolvent or is about to become insolvent, then the directors owe a duty to the creditors. The creditors' interests become vitally important. Of course, when a company becomes insolvent, there's also the likelihood of an investigation by the liquidator. And at that point, the spectre of personal liability raises its ugly head. So when we said before, what does it matter to me as a sole shareholder? Why should I comply with the duties that I have to the company? Well, here's a very good reason. Before exploring personal liability a little further, I'd just like to take a quick look at disqualification. Under the Company Directors Disqualification Act 1986, it is possible for a court to disqualify a director for anything between 1 and 15 years if it is found that they have been in breach of their duties. In the year to March 2011, there were 1,437 disqualification orders made. And that's up 23% in the last 5 years, so it's something to bear in mind. Okay, conduct which may lead to disqualification includes wrongful or fraudulent trading, failure to cooperate with an insolvency practitioner investigating your business, or failure to keep proper accounting records, etc. Now, wrongful or fraudulent trading is obviously an area which directors have to be aware of, especially where the company is about to become insolvent. Fraudulent trading, clearly there has to be an element of dishonesty, an element of fraud. Wrongful trading takes place where a director knew or ought to have known that there was no prospect of the company avoiding liquidation. So back to personal liability. A director may be personally liable if he has breached any of the duties that he owes to the company. There is some relief if he acted honestly and in certain circumstances, decisions made by the directors may be ratified by the company. Fraudulent trading and wrongful trading also attract personal liability, and we touched on that a little earlier. And there are various other laws, including environmental, health and safety and anti-corruption laws, which also carry with them the possibility of the director being personally liable, as well as in some instances of them also being a criminal offence. Now, of those, one I'd just like to touch upon briefly is anti-corruption. And of course, I'm talking about the Bribery Act. The Bribery Act was introduced in 2010, it became law in 2011, and it was described by the Serious Fraud Office at the time as the toughest bribery legislation in the world. And around the world, there's plenty of buzz about this, and I don't think anybody would disagree. Under the Bribery Act, it is a strict liability offence of failing to prevent bribery by individuals on behalf of the organisation, and that's directors, it's also employees, it's also contractors. Anyone who is acting on behalf of that organisation may be guilty of an offence. Whilst it's true to say that there have been no corporate prosecutions brought under the Act to date, that's no reason for companies to get complacent. The Serious Fraud Office has very recently adopted a new Get Tough policy, and effectively what it has said is that if there is a prospect of conviction, it will bring the prosecution. So watch this space. I'd be very surprised if we don't see a corporate prosecution before too long. One thing I should mention, the only defence that you can have against a prosecution under the Bribery Act is to show that you had adequate procedures in place to combat bribery and corruption. So in conclusion, and to bring this sprint through the minefield of directors' duties to an end, and by the way, in any other circumstances, I wouldn't recommend sprinting through a minefield. I'd just like to say that being a company director isn't necessarily an onerous task, but being a responsible company director is a bit more tricky. However, if at all times you act honestly and reasonably, if you take your duties under the Act seriously, and if in doubt, take early advice from professionals, then you shouldn't have a problem. One thing you may want to consider is taking an indemnity from the company for breach of director's duties. This is permitted under the Act, although not in the case of unsuccessful criminal defence or penalties imposed by regulatory bodies. I should also point out that insurance is available to directors for anything arising out of negligence or breach of duty, although obviously that would not apply to anything involving fraud or dishonesty.